Welcome everyone, and thank you for joining us for this estate planning webinar. My name is Dermot Reiter. I'm a senior advisor here at Apt Wealth Partners. And joining me today is Leon McPaul, who is the head of estate planning at Apt Legal Services. Leon has extensive experience in helping families structure their estate plans, navigate complex legal issues, and ensure their intentions are clearly documented. Leon is widely respected across the industry for his thorough and yet practical approach, and we're very fortunate to have him share his insights with us today. Welcome, Leon.
Thank you, Dermot. Pleased to join.
Very good. Well, today the agenda is we're going to talk through why estate planning matters, the key aspects to consider when crafting your estate plan. We're going to give you some tangible strategies for transferring wealth to future generations in a cost, tax, and risk-effective manner. We're going to show you how to navigate some of those complex family dynamics, business succession issues, and then we'll share some of our tips and traps, and at the end we'll take a few questions. So starting with why estate planning matters. Fundamentally, estate planning is all about peace of mind to me. It's about making sure that your assets are distributed in accordance with your wishes. And with complex family structures and the significant intergenerational wealth transfer that is currently underway in this country, proper planning is more important than ever. We're in the midst of a transfer of wealth between the baby boomer generation and the next generation in the order of $3.5 trillion is going to change hands over the next 25 years. And so this area is of increasing importance in our line of work. And Leon, one of the ways that I think about the importance of estate planning and try to motivate my clients into doing something about this important area is to highlight the risks of actually not having a clear plan in place. So why is estate planning important to you, and what are those ramifications of not having an effective plan?
Ultimately, Dermot, clients have worked hard. They've worked hard over their lifetime to accumulate what they have, to have some security, but also to be able to pass that on to their children or beneficiaries. And so they want those things to go to who they want them to go to. Estate planning is all about giving effect to those wishes. In doing so, there is a myriad of considerations, as you'll appreciate, things that we need to take into account. Family dynamics is one. More than ever are we coming across blended families. That's something that has changed over time, that perhaps we weren't in estate law having to consider the same perhaps 25, 35 years ago. The nature of the assets is important. There's, we've got assets that are outside of a person's estate, like super, but then we've also just got the regular day-to-day things. And we need to understand how those things interact and how we're going to pass them on. There's also tax implications of all of these aspects and different types of assets. And of course, more than ever, I think that clients are becoming sophisticated in their structures. They have companies, they have trusts, and family businesses. Small business, as you know, makes up a majority of business operations in Australia. So the estate planning is really covering off on all of those aspects effectively. And so not having an effective plan in place more than ever results in disputes between beneficiaries, disputes between an estate and stakeholders like other business partners, significant difficulties with existing structures, the continuity of a family business so that there's no interruption that will affect its value, its income for people who are dependent on the person that's passed away. But also really peculiar circumstances that can arise when someone has not given proper consideration to their circumstances. And so that really is what we do in estate planning, is try and look at everything holistically and how these things all tie together.
Yeah, I think that holistic element is really important, just looking at it very comprehensively rather than in a silo. So we'll get to some of those tangible strategies, and the key estate planning documents really are as follows, and we'll delve into sort of the key decisions that need to be made for each of them. But starting off with the will is really the foundation of your estate plan. It sets out how the assets that are held by you personally will be distributed upon your death, and it's your executor who carries out those intentions by administering your estate. And it's a key decision to get right. So, Leon, what do people need to consider when nominating their executors?
First and foremost, I advise clients to give consideration to who they trust implicitly to be able to carry out their wishes. Also, what is practical. On occasion, it's not really appropriate to consider appointing someone who may be in a generation older than you, unless particularly necessary. Some people want to appoint their parents or whatever else, and that's fine. But you also need to think of a backup in case those persons weren't around. Generally, at any given time, you can have up to 4 executors, but we can stagger things. We can have executors that are appointed as the primary, but also backup executors in case those persons were unable to act. And so when nominating executors, you also need to give careful consideration to what are they going to do. It's not as simple as just paying out funds. They need to be in a position where they are able to prove the last will to the court, collect those assets and ascertain where they are, arrange sale of assets, and then, of course, when they collect them, they're then a trustee for the beneficiaries of the estate. So it's understanding that sometimes persons you may want to appoint don't want that particular responsibility. So it's a good thing to have a discussion with your executor about, whether they're willing to do that job. But in terms of multiple executors, you can have different arrangements in place. You could appoint them jointly, where it needs 2 signatures on everything, jointly and severally, which means one or the other, or both, or by majority. So always giving consideration to avoiding disagreement. What is practical? Is a person in the state? Are they in the same city? To be able to assist, there's no point really appointing someone overseas unless they are able to be here on the ground. That can be very difficult. But also something that allows for minimal disruption or delay. That's also something else to consider.
Yeah, I think it's really important, particularly with the current landscape around the compliance in banking and all of that. The scrutiny is just been ramped up for more recent times. So just thinking through the practical application of the executors working together is really important to just think that through. So the other major decisions to make in your will includes who the beneficiaries will be, specific gifts or donations you might want to make, and the guardianship of any children. So Leon, what are the key things for people to consider when making these important decisions?
So most clients will have an idea in their mind about who they want to leave things to, whether personal items of property or the bulk of their estate. And that's fine, but we also need to think about the alternative or the alternate beneficiaries. What happens if unexpectedly a child predeceases a parent? Is that child's share to go to their children? And what happens if a child doesn't have children? What happens if you're not survived by your spouse or all of the beneficiaries that you first intended? You can imagine that a young family probably travels together. And these are risks that we need to think about. So often when we meet with clients, we will carefully test these scenarios and explore what is maybe appropriate. And you never want to have a will that comes to a dead end. If there's something unexpected and a will comes to a dead end in terms of beneficiaries, then a person is taken to have passed away intestate or partially intestate. And in other words, the will comes to an end, and so the legislation has to take over. It's as if they didn't have a will. Something else that we really need to think about carefully, and it comes back to blended families, is the complexities that can arise. So more than ever, we have clients that may have blended family, and there could be a husband, for example, that has one child, and the wife may have 3 children from a previous relationship. They could have children together. And so it's weighing up these different considerations and how we approach any type of distribution from a will to those people. And that really depends on the clients and their dynamic and what they want. And so, but on occasion we have the offshoots, the peculiar things, estranged children, previous marriages, children that may have certain needs that are greater than other children, or beneficiaries in general. And so it's quite important to explore all of these issues in detail. And something that we regularly talk about is documenting your reasons. It's okay in a will to have something that's in somewhat of a legalese, and unfortunately needs to be in that way because of the wording needs to be precise. But having something to be able to document, be it a letter of wishes or something that's kept with your will, that says, I've done things in a certain way because, and we can talk more about that in a moment, but essentially that really assists families in understanding how a will maker has arrived at the will they've done.
Yeah, I think that's really important. There's the legal documentation, and then there's those personal aspects, and we'll get to that in terms of what to include in that letter of wishes. But I think one of the other major aspects that you and I both see is that most people don't understand that your will only deals with what's called estate assets. So not all assets pass via your will. So estate assets, as you can see here, are individually owned assets. They might be bank accounts in your own name, term deposits, portfolio investments, private company interests that you own personally, or assets owned via a tenants in common arrangement whereby you own a specific proportion of a property or a unit trust or another asset. Whereas non-estate assets, and these are not dealt with necessarily via the will, are assets owned in a joint tenancy arrangement or assets owned within a family trust or a company structure that continue on beyond your passing. Superannuation, this is a common misconception that people think superannuation automatically flows through the estate. It doesn't, and also life insurance proceeds. So, Leon, particularly for those non-estate assets, how are they dealt with?
So joint tenancy is, we can ignore the word tenant for the moment. It's when a very old English term about being a tenant on the Lord or Crown's land. But essentially, when we're talking about the concept of joint tenancy, we're talking about owning something jointly with someone else, a joint bank account, joint property. And so there is a rule under the law that is called the rule of survivorship. That is, if you hold something jointly with someone else, bank account, for example, and one of those or one of multiple people who are joint on that bank account passes, it automatically at the time of death passes to the survivors. Doesn't go through the will, doesn't go through the estate. So if I own a property with you, Dermot, and I passed, then without even looking at a will, at the moment of my passing, it passes to you as the survivor. And so that asset bypasses an estate, which is quite important to know. That's why that's often an arrangement between husband and wives or domestic partners. So that's one thing that we need to take into account when looking at non-estate assets. Something also is looking at companies. Clients, as I said, are becoming more and more sophisticated as time goes on in terms of their affairs. And so the control of companies is very important, and the succession of those companies. Who holds the shareholding? Is it the deceased, and that shareholding comes into their estate and may be passed on to someone, but in the interim, their executor holds that shareholding and needs to make decisions about this structure, which is outside of the estate. So the will has an influence quite often on non-estate assets. The same as relates to trusts, discretionary trusts, unit trusts, any type of trust arrangement that a client may have set up, usually for commercial purposes or for family-related purposes. And so again, it's very important to consider that structure, and we often need to look at the trust deed that sets up that structure to understand what does it say in the event that a trustee, a client who is a trustee or an appointor of a trust, what happens to their office, trustee office or appointer office, in the event that they pass. And so the role of who is the successor of these structures is very important. And so these things sit outside the estate and they live on past a person passing, and but we have an ability to influence or control what happens to them to a certain extent. And then, of course, superannuation is the big one. Everyone who's working would normally have superannuation, and the issue with superannuation is that most clients do not realise that they do not legally own their super. They do not have legal title to their super. They have a beneficial interest in it. At the moment, and until you withdraw your super, it is held by a board of trustees of a super company. They are the legal owners for the purposes of the law, and they invest it for you and do all the lovely things that they do. And but at the end of the day, when you reach preservation age or you have compassionate reasons or whatever else and you're able to withdraw it, that's when it becomes yours, when it hits your bank account. In the interim, you have a beneficial interest. And so the question then is, what do we do in the event that someone passes, or we're looking at their estate planning, and there's mechanisms available to us to direct what happens to that super. And so often that's through a binding death nomination, as you would know, and you assist clients with. And in doing that, again, we need to look at tax implications.
Yeah, there's a lot to work through there in terms of, because ultimately it can be an estate asset if it's directed to the estate. But sometimes, as you mentioned there, for tax reasons, it might be better to direct it to your spouse or minor children and things like that. So that's just something that needs to be thought through. And I think your point around the family trust deeds and constitutions in the case of companies, you need to look at these things holistically so that your will complements some of those other structures and the documents that give rise to those structures, they need to talk to one another. So that's a very common mistake that people make.
Mm.
Now, one of the other things that a lot of people do as part of their succession planning is they use testamentary trusts. And a testamentary trust is a type of discretionary trust with some special rules that is established under a will. So it doesn't come into existence until the death of the will maker. And there's a few key benefits to this structure. Leon, can you walk us through what those key benefits are?
Sure. So, as you've said, a testamentary trust is a trust that can be incorporated into a will. And essentially, there's two main phases of an estate. One is that when a person passes, the assets that they hold solely or that they have a share of comes into their will, and it's managed by their executors who later become trustees of their will, and they hold it on trust for beneficiaries. As part of that, we can have a testamentary trust where a distribution, a portion of the estate may go to a testamentary trust set up for a spouse or set up for the benefit of children. And that discretionary trust only becomes activated at the time of passing, and if they want to activate that structure, we usually will make it optional. It provides a number of benefits to beneficiaries. It foremost provides a benefit in terms of tax management. So having a trust that has assets and generates an income separate from a person's own income means that we can not only have that income contained within a structure, but then that child or beneficiary would normally be the trustee of their own trust, or in certain other circumstances, they may have someone else, but they would be able to direct at the end of a financial year how that income is distributed. And it's quite beneficial that they may want to distribute to a spouse who's on a lower income, or they may want to distribute to children who may again be on a lower income. And for that reason, it's quite a tax effective structure, because if they had that income in their own name, that would simply be applied to their own existing income on their tax return, and they could be pushed into the highest bracket. Who knows? So it is very beneficial, especially when it relates to children, because existing discretionary trusts that are set up during a person's lifetime, if you distribute to children under that structure, those children are taxed at the highest rate, 45%, highest marginal rate. Testamentary trusts are treated differently. They allow for distributions to be made to children, and they are at the marginal rates, adult marginal rates. So a lower distribution from the trust may allow for it to be in a lower tax bracket, or if it's under the tax-free threshold, it may have no tax. And so testamentary trusts are a great vehicle for the passing of this intergenerational wealth. If we talk about real estate can come into a will and into an estate, and there's no stamp duty on that happening. When it gets transferred to a testamentary trust, again, there's no stamp duty, it is exempt, and that property may generate an income if it's rented out. That income may be distributed each year to beneficiaries of that testamentary trust, and it's only when that property is eventually disposed of that there is capital gains tax. So along the way, all of these transfers don't attract it. It's essentially rolled over. So there's many tax benefits in this structure. The second benefit and important benefit is asset protection. If someone is sued and they have they're part of a trust, which they're a primary beneficiary, but it also has other beneficiaries, classes of beneficiaries that say, and they may distribute to their spouse, their children, their grandchildren, their parents, whatever else, and that person is sued, then they are able to respond to any allegation that they hold property for themselves and say, well, actually, no, my inheritance is in a trust. It's in a trust held for me and other people. And until it is distributed, the law says the interests in it are simply mere interests, mere beneficial interests. And so it protects those assets. In terms of family law and family court, in my opinion, is one of the most powerful courts in Australia, apart from the High Court. It has the ability to consider state law and federal law. My background has also been in family law for a period of at least 13 years. And the family court will consider trust structures, and it will say, who is the controlling mind of that trust? Is it simply a partner in a relationship breakdown? If so, we have the power to look behind this structure. But it can be, if properly set up and created at arm's length, be a good way to keep inheritance so that if parties separate, the court can't actually touch it. The court may turn around and say, actually, it's not controlled by one of the parties, it's controlled by someone else, a professional, or controlled by a different family member. And for that purpose, it's not available for division between the parties. And we can do creative things with the trust in terms of grandchildren, for example. The trustee of the trust may turn around and lend money to them to purchase a property, for example, and that is secured by way of a loan agreement. And if that grandchild is in a relationship and that goes sour, whoever it is that they're in a relationship with cannot say, well, that asset actually, or those funds are available for division. No, they're a loan owed back to the trust, just like any mortgage that you may have on a property. So the three main benefits of a testamentary trust is tax management, asset protection, especially if a beneficiary is in business, and third, family law asset protection if it's set up in the correct way.
Yeah, it's a good point. I think in terms of that asset protection point, that's a question we get a lot about what options you can build into your will. And this is a common structure to be able to build in those provisions. And the way that I look at it is it's kind of like if your legacy is a castle, it's kind of like building a moat around your castle. It's not foolproof. The moat can still be breached, but it just provides an extra layer of protection that you don't ordinarily have. And so for a lot of families, it's a pretty powerful way to at least provide that additional layer of protection. So beyond that, we did touch on before, but the letter of wishes is another important document that I think is often overlooked, and it sits alongside the will. And whilst it is not a legally binding document, it can give guidance to your executors on some of those more important personal matters that are more delicate. And the will deals with a lot of the legalese, but the letter of wishes is a good document to provide some of that guidance to your family around what your real intentions are beyond just the legal aspects. So, Leon, what elements should people include in their letter of wishes?
It's not unusual to have clients include their funeral arrangements or wishes, how they want personal items or trinkets divided or provided to different persons or beneficiaries. more so than ever, we will have clients that, the beneficiaries come in, or executors, and say, we don't know what mum or dad was doing. They were doing some fantastic things, and entrepreneurs. We don't know where they banked. We don't know who their accountant is. We don't know anything. And it's a good opportunity when doing a letter of wishes to be able to say, I set things up in this way for a reason. And my affairs are being managed in this way. This is who I use. This is who I bank with. And this is why I was doing it. And that takes a lot of stress off executors and beneficiaries, instead of trying to work backwards to find out where things are and what's happening. It also allows for clients to indicate why their will has been created in the way it has, especially when providing for persons in a different way. It allows beneficiaries to appreciate that when getting a letter of wishes that may be signed by mum or dad or whoever, and dated, and can help avoid disputes. Compared to just getting something in legalese that says I've done X, having something that explains the rationale is actually really quite important, and carries quite a sentimental weight as well for those that are left behind. Those are some of the main things to do with a letter of wishes. One of the other things that can be included is when there's minors, when there's children. It could be mum and dad that do this letter of wishes that says, in the event of, then this is how I'm seeking the kids to be looked after, essentially. I want them to go to the same school. I'm wanting them to be able to have these opportunities, and provides guidance to executors, because these things are important, but they may be totally unaware as to what the wishes were of the person who's passed.
Yeah, it's an important document, isn't it? And then beyond that, whilst a will comes into effect when you die, a power of attorney can enable someone to make decisions on your behalf whilst you are still alive. So an enduring power of attorney will continue to operate even if you lose mental capacity. So your attorney can make decisions for you in two main areas: financial and legal matters, and also personal matters. So Leon, what are the key aspects for people to consider when nominating their enduring powers of attorney?
The key word in enduring power of attorney is enduring. It endures through an incapacity. And that's the purpose of setting this up. So when thinking about who a person may nominate, for example, in their power of attorney, they need to, again, like the executor role, think about who is absolutely trustworthy for them. These people will make very important decisions. If a person is incapacitated, they essentially step into the shoes of the person who's incapacitated. And so talking about, if I bring it back to the main powers, enduring powers of attorney cover financial matters and personal matters. Financial matters is where you live, your regular financial matters, but also whether someone can bring proceedings on your behalf, whether they can defend proceedings, whether they pursue certain things such as debts, be able to pay debts on your behalf, access your funds. Personal matters is where you live, how you're cared for, who can see you. If there's someone nefarious hanging around wanting to take you to the bank and withdraw money, your attorney can say, no, that person doesn't visit anymore. These are important powers, as you can imagine. And without a power of attorney in place, it requires a person to apply to VCAT for administration or guardianship over this protected person. So when appointing attorneys, you're going to want them to be someone that you trust implicitly, also practical. Are they on the ground and able to assist you from day to day? Appointing someone in a different state or overseas can be very difficult and impractical. You can have more than one attorney. They can act jointly where there's two signatures. It may be joint and several, so you may appoint two people. One may be in a different state, but it allows them to keep each other accountable, so that one here is signing and doing things, but the other can be in the mix, if you like, or by majority. You never want a situation where there could be a stalemate. So if you appoint 3 of your children, you could say by majority, it needs 2 signatures out of 3 to be able to affect these very important decisions. And so those are probably the main considerations that I put to clients when considering attorneys. And also, again, the generation that they may be in. Are they of a similar generation? It's not unusual to appoint mum and dad, for example. If you're a person that may not be in a relationship, but then thinking about the backups as well.
Yeah, that's right. Having good backups and alternates is really important. I think the other aspect to that, which we'll touch on for the next segment, but actually having the physical document as well, certified copies of these documents is really important. I've had a couple of clients where they've gone to exercise these powers and the banks will not deal with them unless there's actually a certified copy in their possession. So it's really important some of those nuanced aspects are taken care of. So the other aspect that we need to think about, separate to the powers of attorney, you need to appoint someone to make medical treatment decisions when you no longer have capacity. So here in Victoria, they call it the medical treatment decision maker as of 2018. Very convoluted and lengthy term there, but for our New South Wales attendees, that's an enduring guardianship, and it's a very similar set of terms that operate in both states. But Leon, what are the key aspects for people to consider when nominating their medical treatment decision maker or enduring guardianship?
So their treatment decision maker has the power to make decisions about their medical aspects and care. And for that reason, again, it needs to be treated with caution. It would be normal for persons in a relationship to appoint each other first and then who their backups are, but they must be in succession. So you're allowed to have 4, but they cannot be joint. They must be one after another. So number 1, and if not number 1, then 2, and then if not number 2, then 3, and going down the list. And that is for the reason that you never want a situation where there could be a stalemate between 2 persons who are needing to provide an important decision to a doctor, and a doctor's in a conflict between 2 people who can't give joint instruction. And so that's why they must be in succession. What would normally happen, at least in Victoria, is that this document takes a form that can be provided to your GP and can be uploaded onto Vic Health and My Health. And that allows for, if there's an emergency and you're admitted in an emergency, that it's available on hospital records, and a doctor immediately has, okay, this person's medical treatment decision maker is this person. It will have their contact details and they can contact them. If they can't get through, then they move down the list to the next on the list. This ability to have it across hospitals and available like that is actually fantastic, and is something that didn't previously exist. Some clients will say, no, I don't want my information on, out there on some type of government-held
Database.
server or database. And so What we do then is we say, well, at least provide the most important people with you, that are decision makers, with certified copies that they can have in their possession, and they just keep for the moment. And that allows, in that emergency, at least they've got it and it can be used. It's very difficult in that emergency to be able to try and run around and find where something is and get certified copies. So that's something that we do, and we find that clients find it very beneficial.
Yeah, it's another example of having the proper legal document in place, but also having or making sure that you're considering these practical implications of how they're carried out in the real world. So, and we'll touch on that in terms of our tips and tricks a little bit later. But one of the other things that comes up pretty often, Leon, is how do we deal with these more complex family dynamics that could lead to people's wills being contested? And what are the best ways to navigate these complexities to ensure people's legacies are protected?
It's imperative. It's imperative to have wills reviewed by a lawyer. The clients that on occasion will go to the newsagents and buy the will pack for $9.99. It's got a lovely tick on the front that says approved by lawyers, and I think it was not approved by me. So that's a false statement to begin with. So you're dealing with your most important assets, and so they need to be reviewed carefully. There are many legal mechanisms available to deal with complex situations, apart from simply cash money. And what I mean by that is, on occasion, a client may think, well, what I've got to do is I've just got to provide them with cash, and that's the way to provide for them. Well, no, there's other things available. An example is a right to reside. So if you have a property and it's in your sole name, or you have a one half share in it, and it's not going to pass to another person under the rule of survivorship, but you have someone that you want to be able to live in the property, you can grant them a right to reside. And that means that they can live there for a period or for their lifetime, whatever you say, but eventually when that comes to an end, it comes into your the residue of your estate, the bulk of your estate, and can be divided between the ultimate beneficiaries. That's one thing. Something that we do and see quite often to do with blended families is contracts to make mutual wills. And what that means is you may have, to give you the early example, a husband that may have a child from a previous relationship, wife may have 3 children from a previous relationship. If one passes under their will, everything goes to the other spouse. But they may have a concern that that spouse could change their will in the future. They could repartner and the dynamic changes. So we have an ability to do a contract to make mutual wills that says you can't change part of or all of your will without the consent of the other person. And that can protect both sides of the family, essentially. And there's a bit more to it, but essentially that's the aim of that document. Other mechanisms that get used quite often, as we've discussed, is trusts. You may have a beneficiary who suffers from an addiction, suffers from alcohol addiction or drug use or something like that. You're certainly not going to want to cut them out, but you're wanting to know that they're going to be looked after. And for that purpose, you can have a protected trust. And that's where their share goes into a trust and is protected. And the executor or trustee will look after their funds and assist them, but they can't access the bulk unless they particularly may overcome their issues and become sober or whatever else, and the trustee determines it's okay. But until that time, their funds are protected. Another type of trust that we can incorporate into wills is a special disability trust. If you have a beneficiary that suffers from a special disability, as what the legislation says, a disability to a degree that they may be entitled to a disability support pension, they may be entitled to the NDIS, you're not going to want a whole lot of cash to go to them if that means it just cuts them off from accessing these other services and benefits, because the government says, well, actually, no, you've got enough to support yourself. And so there's things that we can do within a scope of the framework to allow for those persons to receive not only their benefits they're entitled to, but to also have the benefit of funds in a special disability trust to assist them. The other things that we will consider is, how do we structure the estate? Do we purposefully make assets joint so that they pass to another person to avoid challenges or claims, so they don't come into the estate? All of these types of things we'll consider holistically in order to cater to what that particular client is seeking to achieve at the end of the day.
Lots of provisions there, isn't there? You can build in depending on your unique circumstances. And Leon, for the business owners that are joining us today, what do they need to consider and have in place to deal with their commercial interests?
Business can take so many different forms. You can have a structure where you're running something through a company, or a company as trustee for a trust, or it may just be a simple partnership. You may be a sole trader. All of these things need to be considered. Again, it's imperative to look at the structure, because every person's structure is slightly different. The will, again, influences directly how these things carry on. And we need to consider short-term risks. Short-term risks may be the incapacity of a person prior to them passing. So, for example, it's important to understand that for a power of attorney, an attorney does not automatically become a director of a company that a person is a director of. That is an issue of a lot of confusion. A attorney does not step into the shoes of a director. The directorship is personal to the company, which is its own entity, but they can deal with the shares in the company. So incapacity and considering whether something like a company power of attorney needs to be in place is what is actually important. So the company itself can make a power of attorney because it is a legal person that says, in the event that a director is incapacitated, this person steps into their shoes. And that allows for a seamless continuity and any avoidance of a delay, essentially, in the operation of a business. So that's one thing that we often will look at and recommend straight away when we're looking at companies. But then we need to consider the long-term risks. If a person passes, it's not as simple as picking up a will and running with it. The will needs to be submitted to the Supreme Court, who agrees whether or not it is the last will, it's not revoked, there's not another one floating out amongst other persons, that the person who's applying is actually the executor on the will. And that takes time. For example, in Victoria, that process may take between 4 and 6 weeks from when a person first meets with you, and that's probably an express timeline. I know that New South Wales, as according to a colleague that I spoke to last week, was taking 3 months to have probate granted where an executor is appointed and recognised under a will. That's now blown out to 5 months. So 5 months between a person passing and someone being in a position to attend to all of their assets and their financial aspects and their business aspects is massive. That can break or make or break a family business, for example. So immediately in wills, we need to look at who is the director, who holds any trustee office, who holds the shareholding, and how are we going to deal with that? Normally, we would say the executor steps in and deals with those things. Something else that is important is if you have a company with someone else who's not family, you may need to consider shareholders agreements. What happens to your shares because that person or those other persons involved in that structure may actually turn around and say, well, we don't want to have to be dealing with an estate or someone's family. We want to be able to purchase those shares back. And for that reason, there's things called buy-sell agreements. And that's something that we look at and we do quite often. And then the last thing, and we've touched on it earlier, is the letter of wishes, but also we call it a letter of instruction. Again, it's important that executors and beneficiaries understand why things are set up the way they are and how they're working, because time is critical in that situation. And having something where, and I'll have this on occasion where a client comes in and says, everything's contained on this laptop. It's here. All the information's on this laptop, but I don't have the password. I can't get into it. Or the two-factor authentication to get into the bank accounts goes to this mobile, but I don't have the passcode to get into the mobile. And so those things can be kept in that information in a sealed envelope, for example, that is signed on the back of and doesn't get opened until a certain point. Or the person who makes that letter may hold onto that information, but in a sealed envelope to us, tell us where it is. It's the practical things like that that can actually just stifle the administration of an estate.
Yeah, good points. And I guess flowing on from that, as everyone on the call can appreciate from what we've covered so far, estate planning can be a really complex area, and that's why it requires careful planning. So in light of this, here are my top tips. Firstly, consider discussing your wishes with your family, I think, to reduce the risk of future disputes. And this is regardless of how close your family is. Estate planning is rarely straightforward because of the emotions that often come with it. And it's likely that your family members will discuss the situation with others, particularly their spouses. So there could be additional opinions that you have to contend with as well. So for my clients, I like to get the family together, get them around the table, have an open and transparent discussion. And whilst full transparency may lead to some tension or conflict initially, it also gives everyone a chance to have their say and clarify your intentions as well. So that's a really important thing, getting the family together and talking about it openly. Secondly, your estate plan should also be reviewed on a regular basis, particularly when significant life events occur, such as getting married or divorced, having children, commencing your retirement, or losing a relative that you might have included in your estate plan. So that's really important, and part of our process is to review that regularly as well. And finally, lean on us, lean on your advisors, especially if your circumstances are complex or if you're unsure about your legal requirements. So, Leon, what are the common mistakes that people make in their estate planning, and how do you avoid them?
We've touched on quite a number, but to summarise, planning for incapacity is one that's often overlooked. It's easy enough to do a will, but not consider what happens if I'm incapacitated. Not considering the manner of holding of a property. Is it joint or is it not? Is it going to come into my will or not? Not taking the time to understand the different benefits of different types of wills and trusts and things that can be incorporated into them. The role of non-estate assets, where do those things go? And for what reason, and what are we trying to achieve overall? and not taking into account the tax implications of what is happening, and not considering the individual needs of beneficiaries to avoid will challenges or disputes, essentially. Those are probably the biggest mistakes. And the other things, if I can touch on too, is often not considering what happens in the event of marriage or divorce. Those are two big ones. Because a marriage, believe it or not, invalidates or revokes a will so far as anything that's not left to this new spouse. So there may be things in the will that says they receive certain things, but anything else, any gifts to anyone else, gets revoked. And that can actually make the whole will inoperative. That's quite dangerous. So after a marriage, making sure that you do a will, or you do a will in contemplation of marriage, but also divorce. The divorce revokes any dispositions or any gifts made to the spouse or prior spouse, and again can cause the whole will to fall apart, essentially. So those two life issues come up quite often, and people simply don't recognize the importance of them. And especially when we're talking about marriage, where unfortunately in Australia, the statistics are 49% of people separate. Well, that's 49% of potential wills that need to be revisited immediately.
Yeah, that's a big blind spot, I think, for a lot of clients, that they just don't realize. And that's why you need to work with your advisors and just make sure that if your circumstances are changing, the documents are updated to reflect that. So in terms of how we can help, as we've seen, by integrating the legal expertise and with comprehensive financial planning, our solution is able to deliver more holistic, tailored solutions that are reviewed regularly, lead to better outcomes, and give our clients the peace of mind that their legacy is protected. And that's ultimately what it's all about. So I'd urge everyone on the call that's thinking about their estate planning to please reach out to your advisor and discuss your estate planning intentions, or even just review the current documents that are in place to make sure that they're appropriate. And then if anything needs to be changed, your advisor can introduce you to Leon or one of his colleagues to fine-tune the strategy and provide you with a quote for putting these important documents in place. So that's how we work. It's a very efficient process. And we'll now take a few questions from the audience. Leon, do you have any questions that you've been able to see throughout the call?
I've seen some that have been typed in the little chat. One is, do you upload the past medical power of attorney, or is there a special specific new form to complete with a doctor to arrange the upload? So this form of medical treatment decision maker now is in a form that can be uploaded. If you have one that predates this new form, then it's not in a form that can be uploaded. And the best way to know if that is the case is to look at the medical treatment decision maker that you may already have and see at the top whether or not there's a little box that has room for a barcode, and whether there is a barcode on the left-hand side already. Otherwise, as part of the estate planning that we do, we always ensure those documents are in place and updated so that they can be uploaded. So it is a specific newer form that's only been available for, I think, approximately 5 or 6 years. But it's always worth looking to make sure, because some lawyers actually use their own format, but it is not the format that can be uploaded by a doctor.
Yeah, that's a good call out. Another question that we get quite a lot, and this came through earlier today: how can I protect my children's inheritance from divorce? And we touched on some of the nuances and the provisions you can put within the testamentary trust deed, which is in the will. But Leon, can you just talk to, I guess, some of those aspects to strengthen and bolster that asset protection mechanism within your will?
So when if a asset becomes available, available and vests is what the law says. When it becomes available to a beneficiary, that is when the court, a family court, can say, well, actually, no, this is now in the mix. Whether it's yet to be paid out by the estate or not, it's there, you're going to receive it, and it's available to be divided between you and the other person. The best way to try and isolate this inheritance is either through a testamentary trust, which is established under a will. And we recommend that clients who have children in relationships or may go into a relationship seriously consider this. One thing we look at is who is the controlling person of that trust, because we want to ensure that that child is not seen to be the controlling mind of it. If the controlling mind of the court will say it's in the mix. But another step, a further step, is that when I'm told by clients, my child is in a relationship or thinking of going into a relationship, I immediately put my, instead of my estate hat on, put my family lawyer hat on and say they need to seriously consider a binding financial agreement. And that is what Americans call a prenup. And you can have them before, during, and after a relationship. And we do those. And that can say anything I have on my side of the balance sheet, including future inheritance, stays mine. Anything you have stays yours. Anything we do together jointly can be split down the middle or however we want. But by doing that, what you've done is you've set up a barrier in estate law, but then you've gone further and created another binding barrier under family law. And I have at the moment clients that have children in the UK, and they are doing exactly this. And we're working with the UK lawyers to make sure that this document complies with both jurisdictions. If I can, based on that question, there's actually one about jurisdictions that's come through from a attendee.
Go for it. Yeah.
It says, what should dual nationals do about wills when they have assets in both countries, example, the US and Australia? Do they need a will in each country? Can one be the main will, example, country with the majority of assets, and the other basically say refer to the other one? We have to be really careful when there's wills in multiple jurisdictions, because whilst we are preparing something, another lawyer in another jurisdiction may not appreciate what has happened here. So it is very easy, for example, for a will to be done overseas that says, I revoke any earlier wills, when a client has done a will here. And the law here would say, well, that will revokes this one. And then we have an issue. So there is a number of countries that have signed up to a convention, a UN convention on international wills. And that allows for certain jurisdictions, parts of the US, not all states, but a number of states, other Commonwealth countries, and several other countries that you wouldn't expect, to allow for an international will. And what that means is it's a will prepared here that covers Australian assets. It's a will that covers overseas assets. And as long as it's done in compliance with the convention and has the requisite certificate that it's been done in the correct way here, it is accepted in that other overseas jurisdiction as if it was a will done there. And so we often suggest to clients to have one will where possible. And for the exact reasons that I've just said, We don't want to revoke or accidentally affect another will, and we don't want the same to happen from the other jurisdiction. So it's better to have one document where possible. Otherwise, if that's not possible, then what we can do is a will that says this only relates to my Australian assets. And then we would advise the client, if you're doing one overseas, make sure it does the same. And so that relies on the client to a certain extent to ensure that gets put in place.
Yeah, it's a good point. We've got a lot of expat clients where this is a very topical issue, and I think it's another example of where you need to get all your advisors around the table to make sure that if you do need two wills or an international will is appropriate, or what the asset mix is in multiple jurisdictions, need to make sure that they talk to one another. So that's a really good question there from one of our expat clients there. So with that, Leon, thank you for sharing your insights, and thank you to all who joined us today. We hope that you enjoyed the webinar, and if you have any questions, please contact us or your advisor to discuss further. Until then, bye for now.